Well, first of all, I want to thank ASL for having us here. We really appreciate it. My name is Mital Makadia.
And I'm David Siegel. Sorry.
We are both partners at Grellas Shah LLP. Grellas Shah is a boutique law firm located in Cupertino. Our partner, George Grellas, has been in the Valley, I believe, over 3 decades now, working exclusively with startups. So our firm is a full-service law firm for today's startup. We provide the range of services from incorporation to commercial contracts, handling, employee option issuances, to the bridge and Series A financings, all the way, hopefully, to M&A. In between, we also offer IP protection services.
Trademark filings, patent filings, IP licensing, and we also, in worst-case scenarios, do have a litigation practice. One hopes that no one gets into that situation, but unfortunately, it does happen.
Right. Hopefully not to anyone in this room.
Hopefully not. But.
Our approach at Grellas Shah, we are what's known as a founders firm. There's a lot of firms in the Valley who are providing the types of services that we provide, but we believe we have a unique voice in that we approach it with a view to protecting the founders for as long as possible. So we do not represent VCs. That's not to say those aren't good clients.
No, they're certainly good repeat clients for the firms who represent them, and they're obviously an important part of the startup ecosystem. I imagine many of you in this room who are entrepreneurs would love to get in with a VC who's going to fund them, but while the interests between a VC and a founder are often linked, they diverge, and some of our most unique advice we give is where those things diverge. And some of that we're going to talk about today.
Right. So today's discussion, we're talking about common legal pitfalls and legal issues affecting startups today. We're going to talk about, at the beginning, entity formation matters. I'm sure many people in this room are familiar with that. Also, we don't have unlimited funds, so employment and compensation issues often come up for startups. We'll also talk about the number one issue for startups, which is IP protection. And if time permitting, we'll talk about how to position your company to raise capital. Now, the first startup legal issue, entity formation matters. Whenever we're talking about forming an entity, when we have these sorts of discussions, it's usually, am I a Delaware company? Should I be a California company? Should I be a corporation? Should I be an LLC? Those are all important topics, and there's a wealth of information out there on them. And I encourage anyone, if you're not familiar with that, to discuss it with your accountants, with your lawyers, because it is important. But we wanted to do something a little bit different in today's presentation. We wanted to go a little bit in detail on 2 issues in particular, which I think would be interesting to the folks in this room. But having said that, I do want to cover the basics first. Common equity structure at incorporation. Typically, if you're a startup, you're forming as a Delaware corporation. There's nothing magical about Delaware except that if you do want VC funding, most likely your investors are going to insist that if you're not already a Delaware corporation, you move to Delaware. Now, why is that if you're not familiar? Delaware, there's more protection for minority shareholders in California than there is in Delaware, and typically as the company grows, the minority shareholders are the common stock founders. So VCs being VCs, they want to make sure that they can have a more VC-controlled company, and Delaware provides them that. There's no cumulative voting for directors in Delaware. You can also have a company with just a single director if you're more than 3 shareholders in Delaware. Delaware also has a more established corporate law. When you're a bigger company, that's important to you. But fun trivia, there is one large company that is not a Delaware company. Does anybody know which one of the larger companies is still a California entity? Apple, that's right. So, don't let anyone strong-arm you. If you have the bargaining power, you want to stay in California, you can stay in California if your name is Apple. The other issue is, C corporation versus sub S. I'm sure the accountants in this room can tell you if you're going to take on VC funding, you're going to have to be a C corporation because of the limitations on sub S corporations, namely, which is that all shareholders have to be individual income tax filers in the U.S. VC fund would not qualify, and therefore, if you're going to take on VC money, you're going to have to be a C corporation. At formation time, you do need to make the election, I believe, within 60 or 75 days of incorporation. Yeah, so within 75 days, if you do not elect sub-S corporation status, you'll automatically be a C corp. You'll be a C automatically. That's not to say you can't switch. I think it's easy to go from a sub-S to a C corp, but the other way around would probably be much more difficult. And then the third common equity structure at incorporation is the 10 million share model. Usually when you form a startup, most likely you're going to be recommended that you authorize 10 million shares at in the corporate charter. There's nothing magical about that 10 million number. You can form a company with 10 shares, 100 shares, 1,000 shares. In fact, many of our clients do. But there is a benefit to having employees who are granted, an option to purchase 100,000 shares, know that they're getting 1% of the company. So when they're talking to their friends, when they're talking to other entrepreneurs, they know what they're getting when they say, I have 100,000 shares.
And when they're comparing offers from others.
Right, when they're comparing offers. So that's why people stick with the commonly used model of the 10 million share model. But having gotten that out of the way, we do want to talk about two issues in particular that we think can affect your founder stock and the economics of your founder shares. The first one I'll talk about is preservation of QSB status. Now, again, ASL folks can probably better explain this to you, but the qualified small business stock. Section 1202 of the tax code historically allowed partial exclusion of gain realized from the sale of qualified small business stock if you hold that stock for at least 5 years. Unfortunately, historically, I think that was still subject to the alternative minimum tax, AMT, so it had limited benefit. But that all changed with the Small Business Jobs Act of 2010. As a result of that, 100% of the gain realized up to up to 10 million can be excluded from federal income tax and also from AMT. Now, this is a huge boon for a founder. If you're starting a company, you're in it for the long haul. You hold your stock for at least 5 years. When you sell it, assuming you've preserved QSB status, you can get the up to 10 million of the gain realized from that sale excluded from federal income tax. Yeah.
It's still subject to California.
Okay, so state. Yeah. Right. And the reason why we bring this up right now, and if you're not familiar with QSB, you might be asking yourselves, am I a QSB company or not? Most likely you are, unless you formed your company with millions and millions of dollars. Most likely you are qualified as a QSB company. The reason why we bring this up is because at formation, you want to make sure that you're a C Corp. You can be a sub-S corporation and then switch to C Corp, but as founders, when you receive your stock, you want to make sure that you receive the stock in a C corporation to get the QSB benefit. And a lot of times, companies don't pay attention to that when they're deciding whether to be a C corporation or a sub-S.
Yeah, and that's, I think, one of the key things to take home from this. I understand some of these things we're going to talk about are technical, but one thing that you should realize and take home here is that there's a lot of considerations that go into choosing your initial decisions at incorporation. It's not just what are VCs going to like, because in many ways you can usually easily switch to the VC model from something else, but one great reason to choose a C Corp is this QSB issue, which a lot of people aren't thinking of. On the other hand, it might not be for you. The tax deductions that go with being an S Corp or an LLC might make more sense given the trajectory that you imagine for your business. So these are important decisions to consider at the beginning and talk to accountants who can tell you a lot about this stuff, or your legal advisors to kind of get an understanding of the options. Yes?
No, that's different. That's to make sure that you don't get taxed at every vesting point for your individual stock, because you're getting stock as a sweat equity. So it's essentially deemed as income to the founders. So it's a little bit different.
Yeah.
This is for when you actually sell your stock.
Right.
Is there a limit on the number of different classes of stock?
For QSB, I don't know. I don't think so. But the company can be formed with
Yeah.
other
Yeah.
classes of stock.
Food stock, if you have food stock, if you have different classes of
No, I think that's permitted because a lot of our VCs want to take advantage of holding QSB stock, even when they get Series A preferred.
Yeah, if you go to the point of getting VC financing, you're going to make lots and lots of representations and warranties to your investors. QSB
Is one of them.
is one of them. They're going to almost certainly want you to say that the company's stock would be
It's still a QSB stock,
yeah.
that you haven't done any redemption or repurchases to below the QSB status. The whole thing was designed to encourage investments in startups. So, the VCs would get to take advantage of the QSB exemption as well. Now, the second issue also, if you want to take
Yeah, I'll
that.
take this.
Also is a decision you can make at formation that can affect the economics of your founder shares.
So, we talked at the beginning about this 10 million share model of common stock that's kind of typical in the VC trajectory companies. But that's not the only thing you can do. There are other types of stock available, particularly in Delaware. It's very flexible. And we want to talk about a type of founder stock, people refer to it, called FF preferred stock. The point of FF preferred stock is to give the founders the opportunity to get some early liquidity. So what am I talking about here? Usually as a founder, you invest a lot of your time and energy and give up a lot of things to be part of your startup for years and years, hoping to get money. And when are you going to get money as a founder? You're going to get money at an IPO, at an acquisition. That's when you can sell your shares and actually enjoy the fruits of your labor, right? You're not usually founding a startup for the salary that you might get in a couple of years when you get funding. But as a founder, let's say it's a few years in and your company has gotten VC funding and it has a valuation of $50 million. You might own 20% of the company, but that's not liquid. What is it you really have? You're not somebody who, is really worth $12.5 million in a liquid sense. And also, and I hate to break it to people, most startups don't IPO, don't go into multi-million dollar acquisitions. Even VC-backed startups, more often than not, don't go to these great exits. So founders will often want the opportunity earlier on in their life cycle to take some money off the table, kind of hedge their bets, right? Good VCs are actually often willing to allow this to happen, even though really it's the VC's money that's going to allow the founders to take some of this money off the table. And the reason good VCs want this is it allows the founders to be less desperate and think with the VCs about the long term, because you can take $500,000, $1 million off the table in your pocket. Okay, you've made some money. You can pay your own debts, etc.
Buy groceries.
Buy groceries. So how does FF?
That's what that $500,000 will get you.
Right. So how are you getting this money? You're getting this money by selling your stock, right? But let's say you just have common stock. I will tell you now, no VC wants. Well, I can't say no. Almost no VC wants to buy your common stock. Why? VCs in, let's say, your Series A financing, they buy Series A preferred stock that has lots of rights and preferences, liquidation preferences, voting rights, the special voting rights. They don't want your lowly old common stock that the founders get, right? So how can you get some money from your VC without selling them common stock? Well, FF preferred. So what FF preferred is in something that is issued to founders at the very beginning. And it functions like common stock in most ways. It votes with common. It's convertible into common on a one-to-one basis. It's basically common stock. But it has one magic property, and that is this. If you, as a founder, sell a share of FF preferred stock to a VC as part of the financing round, it will magically convert into whatever series of stock that VC is getting in that round. That's in the charter, in the certificate of incorporation when you file. It says that's what FF preferred stock does. So the VC can give you money to buy your FF stock, and if it's your Series A round, the VC will magically end up with Series A preferred stock. we have here kind of a sample cap table for a company that would have FF preferred stock. And you'll see here we have a 10 million share model of sorts, but we have common stock 10 million shares going to Harry and Draco, here, our co-founders, 3 million shares each. And then we show here 300,000 shares going to Harry and Draco here in FF preferred. It could be anything you want, but we kind of picked this and showed it to you because if you're thinking in the FF preferred thing, we kind of recommend something in the neighborhood of 10% of your holdings being in FF preferred. Why? Because you want to signal the right things to your VC. If you're sitting there and you have all of your holdings, 80% of your holdings in FF preferred stock, you're telling investor, I want out and I want out now. 10% is something VCs can handle and understand. So I'm going to come back to the slide in a minute, but to show you kind of how this works. In a typical VC round, let's say, and this is a small one, the VC is putting in $1 million for a Series A. The VC gives $1 million to our Acme Co, and Acme Co gives $1 million in Series A shares to the VC. How would this work with FF preferred? Well, the VC is still only going to want to probably invest the $1 million, and let's say he's willing to let, or they're willing to let, 100,000 of it go to the founders. So this would be how it would work. The VC gives $900,000 to Acme and gets $900,000 in Series A shares. And then the VC gives $100,000, making a total of $1 million to our founder, and the founder sells $100,000 in FF preferred shares. There are some pros and cons, as I want to go back to the slide, that are somewhat technical, but I want to raise them here just to think about them. So not only does FF preferred stock kind of facilitate the ability for founders to do this whole early liquidity thing, but as the pro here says, it allows early founder liquidity without increasing the 4NNA price. Again, I don't want to get too much into this, but what will end up happening in the alternative, no FF preferred, is the founder sells common. However it is they do, they sell common in that round, they sell common. The problem is that will potentially impact the price of the common going forward. And you want to keep your common price low because that's how you incentivize employees. So if you come after your Series A to Jeff to do your 4NNA valuation and tell him, by the way, we just sold our common shares for $5 a share to the VC, that might impact what he gives you as a 4NNA valuation. And suddenly your employees, new employees are like, I'm getting options for $5 a share. Like, what is that really worth to them? I have a con here. I just want to say quickly, there are some who take the position that there are some tax benefits to FF preferred, that you can get capital gains treatment on selling FF preferred, where with common stock, you're going to, as a founder or service provider, you're going to be taxed at an ordinary income tax rate. That's a debatable topic. I will tell you that either way you want to take, your VC may force you to treat FF preferred sales as ordinary income tax. So some people talk about tax benefits. It's not quite that simple, even if you agree that those tax benefits
We've seen
exist.
it both ways.
Yeah.
We had a client who was able to sell, a few clients who were able to sell FF preferred to their VC, usually not in the first Series A round. I think the VCs are still getting to know their founders, but maybe as they get to know them and understand their situation, maybe in the interim or in the B round, they're willing to let them sell some of their shares. In that situation, they were able to get just capital gains. But
comment on some of his confusion. So
Yeah.
if you have this the FF stock,
Yeah.
right? Isn't it the government that determines how it's taxed? How can it be up to the VC to determine how that particular kind, if you're not changing to a different kind, is taxed?
It's a matter of, you take a position on your tax return with your tax advisor, and there's an audit risk. If you take an aggressive, like anything else, if you take an aggressive position on how something's going to be taxed, there's an audit risk, and if the government comes back, the IRS doesn't audit, they might tell you one thing or the other. As far as we've seen, we haven't had any clients or know of anyone with any clients that this has been tested. And so
the reason why we put that up really
Yeah.
is because the one time where a VC did insist that they take ordinary income tax on a sale was when
Yeah.
the client was selling common stock directly to the company. So the company was doing a repurchase, and that was deemed a bonus for the CEO, as opposed to the CEO selling directly to the VC. If the CEO sold directly to the VC, then it's capital gains, because their basis is usually, 0.0001 cents a share, and then they're selling to the VC at $5 a share. You're paying capital gain on the, $4.90 whatever cents difference. In our particular situation with that client, they didn't have FF preferred, so they only had common, and the VC insisted that the company do a repurchase. And then the company would issue more Series A stock to the VC. And in doing that repurchase, that was, a benefit to keep the CEO happy. That was deemed a bonus, and therefore it was taxed as ordinary income.
What's the difference between having both owners
Mm-hmm.
sell to VC
Yeah.
$100,000 worth of stock,
Mm-hmm.
and put that in their pocket, and the company issues another $800,000 worth of stock, and the company gets that for their
What's the difference from? I mean, it's the same amount of money for the VC. The VC's putting in the same amount of money. It doesn't matter. It's
the
really a
VC
matter of where
gets.
that money. It's a matter of where that money goes. In this setup, it could be both founders or one founder. The $1 million, you have $1 million going to the company. The company has that money for its own general purposes. Here, the company is only getting $900,000 to spend on new technology, new employees, et cetera, but $100,000 is going to the founder's pocket to go on vacation and pay off debts and whatever personal.
Why
But
do you need a whole new issue of preferred stock? That's what I don't understand.
in order to do this for the founder,
Yeah.
essentially to allow somehow the company has to be, either the company is going to give this money to the founder, and it's not just going to be, the VC is not going to let the company give its money to the founder as just a magic bonus, most likely. They're going to want the founder to sell shares and to get this money.
Right.
So the question is, how does that sale of shares happen? The VC doesn't want to buy common stock from the founder. So if we're going to sell the shares to the VC,
Right.
FF preferred stock allows us to give the VC the type of shares they want.
So the question is, why not? Because VCs want stock
Preferred
that
stock.
has preferences, like liquidation preferences, dividend preferences.
Okay, so
Common
yeah.
stock doesn't have that.
All right.
Yeah. So that's why FF preferred. So we I know these were a little bit technical issues, but we did want to mention these two decision points you can make at incorporation or close to incorporation that can affect the economics of what your founder stock may be worth. Then now we'll move on to our second topic, employment and compensation issues. When we're talking about employment and compensation issues for startups, we like to think of it in 3 stages. The first one is when you're just starting out and you're bringing on your co-founders. Second is when you're ready to start hiring your first employees. And then eventually down the line, the third stage would be when you're part of a distributed workforce where you have, contractors or employees all over the country, sometimes all over the world. I'll take the first issue, which is the co-founder issue. Now, this isn't necessarily legal advice, but I can't stress it enough. The number one piece of advice I would give clients is be careful who you're partnering with. Because you could have all the forms, you could do everything right, and whether your shares are subject to vesting or not, if the relationship between the co-founders breaks apart, it's usually disastrous for the startup. Because this is a person who has access to your IP, has access to sensitive information about the company. If the relationship is breaking apart and it's not amicable, usually there's not just dissolution, but potentially litigation as well. And you don't want to be in that situation as a startup. Now, the second issue, founder compensation. Many clients, actually not that many, they should, but many clients ask us, do I need to pay myself? Do I need to pay the co-founders? Technically, yes, you are an executive officer of the company, you're an employee. You've signed an invention assignment agreement, an employment agreement, you are an employee. You should be paid under California law at least minimum wage. Does anybody actually do this? No. But again, I go back to the first issue, which is be careful who you're partnering with. You're starting out in a venture, it's speculative. You both know you're kind of skirting the regulations a little bit, especially in this issue. You don't want to be in a situation where the thing dissolves or there's some sort of disagreement and all of a sudden one co-founder is suing the other for unpaid wages or unpaid minimum wage. That has been known to happen and has happened to a client of ours. It's unfortunate that is the law, but you want to make sure everybody knows what they're getting into and that this is a relationship based on trust. The third issue is documentation versus oral communication. Now, we know how this happens. Somebody has a friend who incorporated, they have all the forms, they just say, here, just use this, change the names. And that's fine, we're lawyers, we understand how that often happens. But just make sure whatever forms you're signing, whatever, you're doing at incorporation, or when you're bringing on your employees, matches what you've actually orally promised to the employees. This happens all too often. In fact, I had a company that I incorporated back in October, and then in January, they brought on an advisor, a strategic advisor. They gave the advisor, I think, 1 or 2% equity in the company. Standard 2-year vesting for advisors is the norm in the Valley. I come to find out in the spring that the relationship didn't work out for whatever reason, and now the advisor is suing my client. Why is that? Because my client had promised the advisor, come join me for 6 weeks. If this works out, we'll be co-founders. I'll make you a co-founder. So the advisor worked, for 6 or 8 weeks diligently. The relationship didn't work out. He terminated him, and now he's suing for $30,000 worth of wages and half the company. Because the documentation was that of a strategic advisor who normally, spends 5 hours a month on the phone or attending meetings. But the oral communication and what was promised was that of a co-founder. So make sure that these two actually match.
I was mentioning to Mital earlier, this summer we had a summer intern at our firm. He's a law student, and one of his first days on the job, I took him into a potential client meeting. A new client came in and told us the story that they were being frozen out of their startup. They're a co-founder. And it was, it went well, what have you. And after the meeting, the intern was like, wow, you seem to really know how to handle that. I didn't even know these things really happened. And I'm like, unfortunately, several times a month, we might have clients come in like this. Like, this happens more than you might think. And so while we all hope that, and have to rely on trust with co-founders for many, many reasons, having things documented correctly and having those kind of safeguards are essential in case things go wrong. Because really you want signed contracts that do things like actually sign contracts that say how many shares you're getting and how they're going to vest, and don't have separate agreements apart from that, like have stock purchase agreements with vesting terms in them. If you're going to have someone as an advisor, have an advisor agreement that explains how their IP is going to be assigned and what they're going to be doing. And again, don't have some other discussion about, well, this is an advisory thing for now, but the idea is you're going to be a co-founder down the road. All too often, either people do a lot before they incorporate and make oral agreements and don't document them, or they do document things but make oral promises to each other that don't match that documentation. Both of those can end up in really nightmare scenarios for your company.
And email communication can count as documentation.
Evidence.
Yeah, if you're in litigation.
Right.
And the whole point is to avoid being in that situation.
Right.
And if what you have is a solidly signed contract,
Yeah.
hopefully, no lawyer on the other side will take that case on. You
Right.
want to get to a point where it's solid and winnable without taking a step into the courtroom.
Right.
How should you do it for alleged incompetent?
Was that?
I'll plead the fifth on that. Alleged incompetent advice.
Never.
The second stage.
I don't think that's it. So, okay, now you're past the co-founder stage and you're bringing on a new service provider. We'll call them service providers for the moment for a good reason. And one of the big issues that comes up is this person we're hiring an independent contractor, a consultant, or an employee? And this is a really important question because most startups, when they bring on their early people, don't want any of them to be an employee. Because what does it mean to have an employee? You have to pay them minimum wage at a minimum. You have to give them pay stubs and pay them on a certain regular basis, withhold payroll taxes. It's a pain. But unfortunately, it's not up to you as the startup or even the employee to decide whether that, or the service provider, to decide whether this relationship is an independent contractor relationship or an employee relationship. That's not how California law works. Instead, what there is there's actually a test of like about 20 factors that a court or the labor board, California Labor Board, will look at to determine if this person is actually a contractor or an employee. And I will say right now, the labor board in particular is, as well as courts, are not remotely hesitant to ignore contractual agreements you might have with a service provider that say you are not an employee. That really just doesn't hold much weight. The types of things they look at, we put some here, but some biggies are how much you control what the service provider does in terms of hours, where they work, how they do their work, can they subcontract out what they're doing? Are you providing this person a laptop to use or a phone? Are they working for multiple companies at the same time? There's a whole bunch of different factors, and unfortunately, look, the reality of startup life is you probably will not have the funding at the initial stage to avoid the problem of somebody who's really an employee not be treated as an employee, but you do need to realize the risks there. And I will tell you, unfortunately, the sad part is if it's a disgruntled person, they can quite easily, when they leave, file a claim with the labor board. It doesn't cost much, and they're not exactly employer friendly. One thing this points to, just if you have somebody who's leaving, a nice idea, get a severance agreement where they release claims against the company. That's one way out. Even if you really don't like somebody, giving them some money that you have to get them to sign something is a potential lifesaver going forward. Another issue here, I say improper vesting for equity compensation. The reality is for your early service providers, you're probably going to be providing maybe only equity compensation. You'll only be providing stock, you'll only be providing options. So I imagine a lot of you are familiar with the concept of vesting, where your rights to shares or options vest over time. Over time, like if you're granted 100,000 shares, you have 4 years and basically 250,000 of those, 25,000 of those shares vest per year. And if you leave early, you don't get the unvested shares. So there's two issues that we see arise in that context. One is not doing vesting for your early service providers because you trust them. If you don't have a vesting schedule for them and you grant them 100,000 shares and you're agreeing just verbally they're going to be there for 4 years and they walk out the door the next day, they're walking out with 100,000 shares. That's really not something you want.
That's usually rare.
That's rare.
But it does happen.
What's more common is where you don't have what's called, I'm going to talk on both sides of this one, but bear with me, where you don't have a cliff. So very standard vesting term, people will say 4-year vesting, 1-year cliff. What does that mean?
It's so ingrained in the Valley,
It's so
too.
ingrained
Everybody
in the
knows that.
Yes,
4-year vesting, 1-year cliff.
What does that mean? It means you vest monthly over 4 years. So every month you get 1/48 of the shares vest. But during the first year, nothing vests until the end of the first year. The first year is like a trial period. So if you fire the service provider within the first year or they quit within the first year, they get nothing. But right after the first year, the first quarter of the shares vest. So that's a nice idea and something to think about, so that if somebody's really not working out at the beginning, you have this kind of trial period and you haven't given them any shares. Now I'm going to talk on the other side of my mouth about the other side of a cliff and the other side of improper vesting, which is having vesting terms for people you're only paying with equity and they're not getting any money. The problem here in that scenario is if you're going to do this cliff where there's like a year where they don't vest in anything, you can run into a problem. And here's the problem. Let's say they work for 6 months, develop some code for you. You want the code, but it's okay, but you don't want to keep them for other reasons. So you fire them. So you have this code, but they haven't vested in any shares, and you're not paying them anything. They've literally gotten nothing for their 6 months of work. The problem here is the company's right to own the code that this service provider did is based on a contract. And the contract said contracts have to go both ways. The employer has to get something and the employee or service provider has to get something. Here, the employer wants to get this code and is giving the employee service provider nothing. So that service provider can potentially sue you and say, you have no rights to the code because you didn't give me anything. I got no shares. I got no money. So if you're going to have people who are service providers who are getting just equity, you need to make sure one way or another you're giving them something so that you own their IP. It might be that you have a cliff for the equity, but you give them some small token amount of money for the first 6 months or a year. It doesn't have to be much. It could be $100 a month, unless they're considered an employee, and then that won't be enough. But that's a separate issue. That doesn't actually impact IP ownership. So again, I'm talking on both sides of my mouth, but the important thing is cliffs are great, but you got to give these people something if you're going to own the IP they create.
All right.
Good characteristics of the independent contractor.
Good characteristics.
Working for multiple companies.
Working for multiple companies, work when they want, where they want, with their own resources. They can have a friend do part of the work. They're specifically allowed to subcontract.
But these things are not within my control as a startup owner.
Sure they are. Your contractor agreement can specifically say you're permitted to subcontract. You just mentioned in the agreement, no training. You don't do any trainings. That's great. That's in your control. If you do trainings for them, that's a bad factor for you as a startup.
You don't give them business cards.
Yeah, don't give them business cards.
You don't make them show up 9 a.m. every morning at your garage or wherever you're working from.
Yes.
I mean, regardless of what the labor board may determine, as the control as the employer, isn't it just as simple as whether you issue a W-2 or 1099?
No, it isn't.
Why not?
The 20-factor test.
The 20-factor test. I mean, you
can
can
look at in reality what was.
After, like I said, that's for the California Labor Board to determine what is correct or not.
Right, whether
it's a risk factor.
It's a risk factor.
In terms of you, as an employer,
Yeah.
you've decided, you've done the test, whatever, you are going to make, but whatever, I'm not talking about what went into that decision. At the end of the day, you reach a decision. Contractor or employee, isn't the kind of tangible output of that is just what the W-2 or 1099.
True. You can make that decision.
Or what the employer has to do.
Right. So if I'm an employee, and I need, whatever, but and I think the labor board would agree with me, whatever, and the employer issues me a 1099, I mean, that says that they, for whatever reason, do not feel I will be ever considered an employer at any point like that. Because I've heard things, even though I received 1099, I've been told, well, if you have one client for, more than half the year, and, and all that, and so that you can essentially be an employee whether they like it or not in the end, or they have to convert you technically from a 1099 to a W-2 after the majority of your work is for them as opposed to anyone else.
I don't know technically when it's supposed to, when the conversion would
that's
happen.
not a hard and fast rule. But it can happen. You could be in a contractor position and circumstances require that you become an employee, and so you go from a 1099 to a W-2. That happens. Larger companies happens all the time, but it happens in startups too. But the important thing that we're trying to make sure people walk out of here knowing is that whatever decisions they make in terms of kind of agreeing with your service providers, the law makes its own decisions as to
that it's not questioned. That later on, no one is saying you misclassified.
Right. Yeah. And the penalties are steep. They're really, really, really bad. Yeah. Yeah. So you can pay, yes, you don't have to pay any more than minimum wage. You certainly can pay anyone who you consider key, let's say minimum wage, and withhold payroll taxes, pay them every 2 weeks with a pay stub that has all the required things. and follow all the labor rules.
Most startups don't.
Most startups don't. It's an administrative hassle, but I don't want to discourage anyone from doing it, so I'm going to be quiet.
So the third stage is when you have a distributed workforce. I'll try to speed through this, but once you start hiring remote employees in India or in Russia, Canada, New Jersey, now you're part of the distributed workforce. You want to make sure, you want to realize that when you hire an employee in New Jersey, just because you're a California company doesn't mean that New Jersey employment law does not apply. Employment law is based on the jurisdiction of where the employee is. So this may require you to follow, for example, New Jersey employment regulations, and also qualify as a foreign corporation to do business in New Jersey. So when you start hiring people, be aware of that. And I can't let this presentation go without mentioning my number one pitfall, which is that pay everyone when you terminate them. Don't wait till the next payroll if you are paying your employees. Don't wait 3 days because you're angry with them. Pay them on the last day that you terminate them.
You have no leverage there. Every day it gets worse.
Every day gets worse, and there's steep penalties. Okay.
All
IP
right.
matters.
Okay. There's a lot to say about IP. Obviously, can't say all of it.
Yeah, we have to shut up. He can go on and on.
Needless to say, IP is for tech startup people, which I assume most people here are, is kind of the most important asset that you have. Unfortunately, it might be the biggest liability that you potentially can have as well. And it's kind of two things we want to say about IP issues for startups, which is what kind of protection can you get, and what kind of problems you can run into, how do you run into problems, and, well, I guess this third thing, which is how to make sure your company owns the IP it thinks it does. So I want to briefly just go over the major types of IP protections out there, because there's a lot of misinformation and misunderstandings. And this stuff matters because you sometimes have to do things to get the protection you want. So there's four main ones. And the first one is patents. And this is one a lot of people focus on. And patents, we say here, protect new and useful inventions. I like to think about patents as protecting functional things as opposed to this other types of IP. Patents is the one that's focused on what function things have. Patents, they have a limited duration. It's a monopoly, essentially, for a period of in the neighborhood of 20 years. Some examples, guys probably know this kind of thing, but technological inventions, pharmaceutical products, also certain types of methods of doing things can get patent protection. The hitch with patent protection is it is expensive to get. You have to file a patent application. Those can cost, $10,000, $20,000, $30,000. It depends. It takes years. But obviously a monopoly is huge, and monopoly value is huge to startups or any technology company. You got to make sure that if you want to patent something that you actually go and do it. We're in a first-to-file world now, and so the first one to file a patent application for something is the one who could potentially get it. And there is a notion out there that if you talk publicly about your invention, that you have a year to file an application. For the most part, you might see that online. For the most part, ignore that, particularly because we're, again, in a first-to-file world, and if you tell someone about your invention and they file first, you can end up in trouble. You can do that with a provisional patent, which is cheaper, but in the long run, it often isn't. But yes, if you have limited funds, it won't necessarily save you in the future, but you can spend a few $1,000s getting a provisional patent application out there to kind of preserve your rights. When I said that patents are expensive to get, the only thing more expensive than that is they're expensive if you infringe. Patent litigation is notoriously expensive. I'm talking 7-figure numbers to bring or defend a patent litigation suit. At the beginning of my career, I was an IP litigator. I went to trial on a patent case, and I will tell you, the courtroom had 85 lawyers. That's how many lawyers it took. And that wasn't because there were 85 parties. It's just that much, it costs that much to do these kind of things. And there's essentially no such thing as I was an innocent infringer. I didn't know. It's if you infringe someone's patent, you don't have to know that patent exists. Copyrights. Copyrights protect original, literary, dramatic, musical, or artistic works. In some way, software. basically creative stuff. When we're talking about copyrights, we're talking about creative things. Important here, it protects an expression of the idea, not the idea itself. So you can't have an idea about a story about a sorcerer who goes to school in Britain and, fights some bad, evil wizard. You actually have to write a book, put it into paper called Harry Potter. That book gets copyright protection, not the idea around it. Copyright protection, it's actually complicated how long it lasts, but you're looking for a company in the 95 to 120 year range. So it's longer than patents. Examples of it, I already said books, music, again, some types of software, but that gets pretty complicated. The nice thing about copyrights is, how do you get copyright protection? Have an original idea and put it in some sort of tangible form. You don't have to file anything. It's just, you write it on paper, it's copyrighted. If you want to file a copyright lawsuit, perhaps, then you have to file with the Library of Congress Copyright Office. That's cheap, easy, and literally you can do it the day you file your lawsuit. So if anyone says you need to file copyrights, if any lawyer tells you need to file copyrights, think twice about the person you're talking to. The other nice thing about copyrights is this is nice and bad, there is kind of an innocent infringer defense in that if you come up with the same idea as someone else and put that identical idea on paper, you're not liable for copyright infringement unless you actually copied the paper that they had their idea on. So you can independently come up with the same idea. That's not the case with patents, as we said. You can infringe a patent without ever knowing that the patent exists. The sad part about that is that other people can copy essentially create the same idea as you and put it onto paper. Create code, for instance, that's the problem with software. Create code that does the same thing your code does. Unless they copied your code, it's not copyright infringement. So that's kind of one of the limitations of copyright law. Again, when I talked about patents, I said it protects functional things and copyrights protect creative things. Copyrights can't protect the function of software, unfortunately. Trademarks say protects words and design used to distinguish goods and services from others on the market. Essentially, it's branding related things. Trademarks, unlike copyright and patents, can last an unlimited period of time, which is nice, as long as you're using it in the right way. You can apply for trademarks. You don't have to apply for trademarks. If you use the right kind of term or the right kind of branding in the marketplace in the right way, you get trademark rights to that, even if you don't file a trademark application. Trademark applications, on the other hand, have huge value, particularly for startups, because you might have this great name. I'll just use Acme again to be boring, but for your software service, you want to call it Acme, but you're not going to be in the marketplace offering it for a year. If you can file a trademark application today, well before you're in the marketplace, and get priority for that mark today with what's called an intent to use application, which gives you, which helps you in case somebody 6 months from now decides to create an Acme software service that does something similar. So there are benefits to filing a trademark application. It's just not required. Yes.
Now, regardless of filing, I thought there was a common law aspect to it.
Yes.
Like if you used it
right.
and were known in the similar industry, it can't be whatever.
Yeah.
Forbes and Acme software.
Exactly.
But that you still have the voting right.
Right.
Regardless of filing.
So if you're using, as I say, if you're using a mark in commerce, you don't have to register it to get rights, and that we refer to as common law trademark rights. That's the term we use.
But that usually assumes you're actually out there
yes.
using that name. I think that'd be applicable to like restaurants.
Yeah.
If a restaurant made it big, most likely they haven't bothered to file an actual trademark application with the USPTO, but everybody knows them. That name has common law value. But if you're a startup and you haven't actually started selling your app or your software, then you want to file an application.
One of the other really important points you brought up is the idea that this Acme Forks versus Acme software. The thing with trademarks to realize is two people can use the same trademark as long as they're for sufficiently different things that there isn't, quote unquote, likelihood of confusion for consumers. So the Acme Fork Company selling forks and the Acme Software Company, it's people in the marketplace aren't going to think, oh, Acme Forks, Acme Software, they're the same thing. It's probably not going to be confusing, so they could both use it. Yeah.
Clarification on that,
Yeah.
though. So Acme Forks has been around for 100 years.
Mm-hmm.
Acme Software comes along,
Mhm.
and Acme Forks is a well-known brand. It's
Mhm.
something completely different. And Acme Software, their logo
Yep.
looks in color and look and feel
Mhm.
looks very similar to Acme Forks.
Mm-hmm.
Basically to potentially take advantage
Yeah.
of the brand recognition.
Yep.
Is that considered?
So let's
Most
take the
likely,
logo
I would
aside. You're getting okay. So with the name, it's probably fine unless it's super super famous, and I don't want to. But we're talking Coca-Cola level famous,
Right.
and that's a whole different story. With the logo, you get into this issue of, from a trademark perspective, it's probably fine. But your logo is a design, and you might have copyright protection for that logo, even though you also have trademark protection. So and copyright, none of this likelihood of confusion thing exists. So if you copy someone's logo, you can end up infringing, even if you're not infringing trademark, because you infringe their copyright. So it might not be good, but not for the reason you might have thought. Oh, actually, I think, did you have a question?
I was just going to bring up the recent lawsuit of hospital
I'm not even aware of it. Wait.
They were-
I'm not, so I don't.
Yeah, I think they were selling Tiffany branded products in their stores.
They used the word Tiffany.
Yeah.
They did not use the blue box.
Right.
They called Tiffany's. And it was a tricky, it was an interesting one.
Yeah.
Really came down to whether or not customers would be
Confused.
Right,
And that's what's happening.
and so a trademark litigation lawsuit, if you ever get into that world, literally you will have market research surveys done of consumers to see if they're confused. That's what it ends up coming down to. Oh, wait, did you have a question?
So in terms of patents, like
Yeah.
you work for a corporation or a
Yeah.
entity,
Mhm.
and it's not patent.
You file a patent
Yeah.
personally?
Yeah, no, I mean with companies. you file a
Oh,
patent.
the company files patent. Okay, yeah.
You file a patent, you are the inventor.
Mm-hmm.
And $1 million of your whole company
Mhm.
has done some due diligence on terms of patents and relationship or not very clear cut. Right?
Mm-hmm.
And if you come and do something different what other companies doing.
Mm-hmm.
So is that a great spot?
Can you hold off on that question for a minute? I'm going to get into that world of things in just a minute if you hold on, because it's the next slide. Did you have a question?
Yeah, just I think where a lot of startups work with copyright, is
Yeah.
like they create a web page
Mm-hmm.
and they start using just pictures from stuff you find on the internet,
Mm-hmm.
and then they don't realize till there's an address you get contacted and you get a letter saying, hey, you used my picture on your website without my permission.
Yep.
And then you get hit and then you have to kind of take down your
Yeah.
website right away or case settle and say, oh, we'll settle outside.
Right.
It's very common.
And let me tell you, copyright, there's statutory penalties, like for each time you infringe, there's a certain amount of money, it's a range, but it can be $30,000, $40,000, $50,000 each time, and the plaintiff doesn't have to prove anything. They have to prove you infringed, but not the amount of damages. Just quickly, trade secrets are what they sound like. They're things that have value because you keep them secret. It can protect anything as long as it's essentially secret and you take steps to keep it secret. There's no filing of anything, nothing of that sort. Very quickly, this I think gets to your point, but I'll follow up with your question in a minute. The other important side of IP is making sure you as a company own it, and that means getting invention or IP assignment agreements for every service provider that you have, no matter how little or much they do. A lot of clients we have come in and they're like, well, we got an NDA from someone. Forget it. No, the NDA just says keep things secret. It doesn't say who owns what. You need to have the assignment language in part because at best without it, the most you might have is some sort of implied license, which is not what you want. The employee or service provider could then go off. They own it. They can go off and do the same thing because all the company has is a license to use
Even
it.
if you pay them a salary.
Even if you pay them a salary. the wording of the assignment actually matters. Several years ago, there was a lawsuit about this, that if, for instance, you say in a contract, the employee says, I agree to assign all IP rights to the company, not good enough. You have to actually say, the words matter, I hereby assign all rights to the IP to the company. That difference actually matters. And you need proper consideration. The employee service provider has to get something, as we were talking about earlier, in order for the contract to be enforceable by the company. Now, you were talking about, so an employee creates something while they're at a company and then leaves, and then the employee's new company tries to file a patent, or the original company tries. What was the situation you were talking about? Okay, you can ask me after. Well, something related to that idea, at least. You as a company want to be able to file a patent application on something your employees create. You need the right language that allows you to do that. You need the right language that allows you to actually file the application. So this is just something that you have to make sure to button up for every single service provider. The alternative, by the way, you get a VC funding round, you're going to be chasing your old contractors and employees, etc. Some of them might not like you anymore, to get them to sign things, and you don't want that.